Good. Okay, welcome everybody. This is the call to order for the Chesapeake Beach Board of Appeals. This is March 6, 2025. We are here today to approve some meeting minutes and deliberate on case 2023-03. As normal, we begin with a roll call for board members. Please announce if you are here. Mr. Paul Doherty.
Present.
Ms. Amy Everett.
Present.
I am Mr. Jody Hoon-Star. We have a quorum. I'm going to go through and do a bulk meeting minutes approval. This would be for all the meeting minutes for case 2023-03, for the minutes of October 21st, 2024, then January 15th, 2025, and that has both an open and closed session. The February 3rd special meeting, which was to open and then go into a February 3rd closed session. Everyone cool with that? Okay. Does anybody have any changes or issues with the minutes as they are, as they've been? Okay, in that case, I will entertain a motion to approve the minutes in bulk.
I move to approve them in bulk.
I will second that. Aye.
Everybody, thank you. Okay, we now move on to the Board of Appeals continuation. As normal, case 2023-03, Rod and Reel Incorporated, Donovan Estates LLC, to consider an application from the Rod and Reel Incorporated, Donovan Estates, 4160 Mears Avenue, Chesapeake Beach, Maryland, for a decision on interpretation or alleged error to Article 6, Section 29023, 29031, A1 and A6 of the Chesapeake Beach zoning ordinance, and C309, C310, C311 of the Chesapeake Beach Town Charter. Applicant requests the Chesapeake Beach Zoning Board of Appeals to, quote, order the zoning administrator and planning and zoning commission to immediately commence and prioritize the processing and review of the relevant site plans submitted by the Rod and Reel Incorporated Donovan Estates, and that the zoning administrator and planning and zoning commission be ordered to apply the zoning ordinances in effect as of January 29, 2021, when the applications were submitted, and for such other and further relief as the nature of their cause requires. Okay. Before we open the deliberations, I just want to do a couple announcements in terms of how this is going to go. According to Section 29032L, at the close of our last public session, we have 120 calendar days to deliberate and reach a resolution on this case. The hearing's been extensive, and in order to comply with this 120 limit, we've reserved 3 dates for this board to deliberate. Today, March 6th at 6:30, Monday, March 17th, 2025 at 6:30 p.m., and Monday, March 31st, 2025 at 6:30. We might not use all these sessions. It's unclear if we'll need them. They'll be for a maximum of 2 hours. And the goal of these 3 sessions is to ensure that our legal counsel has adequate time to work with whatever determination is made by this board. At any point in time, just a note for our board members, if you feel like you are at capacity for this particular meeting or the one on the 17th, feel free to just kind of raise your hand and say, let's take a pause. You can come back again at one of the later dates. So don't feel like you have to feel rushed, or if you'd like to go home and reread certain things, we can close this down early if you so would like. Okay. Yeah. Yeah, thank you. Yeah, that sounds good. We can do that. One more bit of administrative advice, which I don't think applies for the members here today. Some concerns have been brought to my attention about whether board members can participate and vote on this case if they have not been present at all sessions. This stems from Section 29032C3, which states that all actions or decisions of the board shall be taken by resolution in which 3 members present during the proceedings must concur. Our folks with a legal background have stated they believe that this means only board members who have attended all sessions for case 2023-03 can sign their name to the board's decision. By my count, we've had 18 distinct meetings for this case. It's been over 500 days since the first hearing, nearly a year and a half. The rules that govern this board, unsurprisingly, don't handle situations like this well. Members of this board are volunteers who have dedicated significant time outside of their home and work to improve the town of Chesapeake Beach as best they can. As we proceed, if other members, aside from us three, should attend later sessions, it's my intent to allow them to vote as they see fit. And in the event we end up in a split decision, we will revisit how that applies to the 29032C rule that was just read. Okay, that's neither here nor there since all of us have attended. Okay, we are ready to begin deliberation. At this point in time, I would entertain a motion to begin deliberation.
I move to begin
I'll,
deliberation.
I'll second that.
All in favor? Okay. So I think the board has heard a lot over these past meetings. And the kind of the first thing I guess I would like to do is offer an open session to board members. I'd imagine this would be more along the lines of an informal narrative for your full understanding of what you've seen so far. You don't have to, but we've been sitting quietly for a long time. Would you like to wrap up your interpretation of what's happened here so far in a couple sentences, or should we just not?
I don't think a couple sentences suffices. So for me, that doesn't really apply.
Yeah, I wrote a lot of notes here, and it might be helpful. I've got a little, I don't know what you want to call it, sequence of events. Right, so let me read this if I can. So the appellant submitted the site plans January 29th, 2021. And some of those plans were in the critical area. The town code states that the commission, the Planning Zoning Commission, must decide on a site plan in the critical area within 60 days. Before that 60 days expired, the town council passed a resolution placing a moratorium on review of Category 1 site plans. The moratorium was recommended by the Planning and Zoning Commission as a temporary moratorium to last no more than 12 months. The resolution passed by the town council also described it as temporary, but with the expectation would last 9 months. But then as the 9 months was about to expire, the town council took a positive action to extend it to 3 additional months. That action implied to me that the moratorium was still viewed as temporary with a specific duration. But then at the end of the 12 months, it just continued with no action by the council on the resolution. So at that point, it appeared to me to have become a moratorium of indefinite duration with no end in sight. And it was not until a year later that the moratorium was formally lifted by the council. So a duration of approximately 2 years. Prior to that time, the appellant attempted to have their case heard by the Board of Appeals. I believe it was in 2022. Their application for an appeal was refused, turned back, and the appellants filed with the circuit court to obtain a court order to have this case heard. So in my mind, that it's an unusual chain of events. The other statement I wanted to make is that, you know, reading a close reading of the code that empowers this board, specifically appeals of this type, is that we are empowered to rule on errors by the administrator or commission, on determinations, decisions, or orders resulting from errors of interpretation of the zoning code when they're acting in an administrative capacity. So it seems to me to focus the discussion, we should look at those points where a decision or action was made and whether that resulted from a misinterpretation of the code. And then we can rule on that.
In few words, I agree with you. This doesn't really fit with the timeline of events, but one of the things I'm concerned about is kind of treating our decisions in like a domino effect, right? Where if we decide that there was an error, that the domino falls into places that we may not have oversight, right? Like a town council decision or ordinance or resolution. Those to me felt like they followed from a potential decision from either the administrator, planning and zoning, but I'm very hesitant to let that domino fall and knock over further ones that seem outside the scope of this board. Does that make sense?
I'm not sure I'm following you.
So I'm hesitant to make any determinations regarding ordinances and resolutions from the town. I'm not saying like
My view of it is that our focus or our authority is limited to decisions, actions made by the zoning administrator or the commission.
Mhm.
We have no say in any decisions or actions outside of that. Decisions and actions made by the town council, by the mayor. I don't think that's within our jurisdiction.
So I think that you guys are, I'm kind of tracking with both y'all in different ways. But I think that we do need to look at a timeline and see what decisions were made, decisions by the planning and zoning administrator or commission, right? But we also need to look and see what actually is in our purview, and that any of error or interpretation that we need to look into has to be within this chapter. And so we need to determine if there are any decisions, orders, whatever, that we will say that there was an error. But then we also need to make sure that we are staying within the chapter that we are.
zoning.
Yeah.
Zoning chapter two.
Yes. And I think that we need to decide if pieces and parts are relevant to our case as they might be outside of that chapter. Right? So are certain pieces of this, a moratorium, a resolution, are they outside of the chapter? And if they are, is that even in our purview? So we need to find those critical points, see if criteria is met, and see if it even pertains to us.
I think there were two critical points. One is when the plans were first submitted in 2020-21. The time period between when they were submitted and when the moratorium was passed by the council. I think once the moratorium passed, it was out of the hands of the zoning administrator, out of the hands of the zoning commission. So anything that happened during that moratorium, I think is out of our purview.
Yeah.
And our focus, the second point is when the moratorium was lifted.
Those were the two that stood out to me too, was that period in which, prior to any discussion by the town council about moratoriums, how the applications were handled. And then again, if we believe that the moratorium expired, my notes here say that you could take this from two sides. One is that yeah, the town council got together and voted and extended it, and then those extensions expired. And that might be more from the perspective of the rod and reel. And then the town might get together and say that it doesn't end until they voted on March 16th of 2023 to actually formally terminate the moratorium. And it's a bit of a you know, I don't really know which ones,
Yeah, I don't feel that the moratorium, the way it was written, the wording, I don't think there was an automatic expiration.
you don't think it expired?
I don't think it expired by itself.
Okay.
I think it expired when the council passed the resolution
In March of 2020.
lifting the moratorium.
Okay. In that case, that takes away one of my the 2 points where I think we had to consider something was the second of which was if the moratorium expired and the new zoning map and the implementing ordinances weren't passed and there was a gap between an expiration of a moratorium, 9 months plus 3, however you want to map it out, and then the pickup of the zoning changes. That was one of my second kind of inflection points, but yeah, yeah. I can't say I feel strongly about either argument.
But let's talk about the first point in time. The site plans were submitted. Nothing happened with them.
As far as
in the
we,
7 weeks before the moratorium. So was there an error there on the part of the zoning administrator or the commission? Was there an error of interpretation? Was there an action or a decision? I think, although, well, a week after the site plans were submitted, the zoning administrator sent out an email to,
the response letter.
it was an email, right, to Paul Woodburn with a CC to Mr. Blitz, stating that the site plans were a burden, a moratorium was being considered. I think that's evidence of a decision not to process the site plans at that time. So the question is, was that as a result of a misinterpretation of the code?
Yeah, there was, I can't remember the line. It would take me some time to find it, but there was also a stipulation in the zoning was the ability of staff members to consult with additional parties. Was Jakubiak, I mean, we can read into his letter that he had discussed what was going on with other parties. Was he following his guidelines in making an appeal to the town council as part of his duties? Was, you know,
Can you repeat that again?
sorry, yeah, when inferring from the letter, let me pull up the date, on 2/5, pretty much the second letter after the second event after the site plans were submitted, it read to me that Jakubiak had reached out to other members of the town to maybe discuss what was happening given his workload and the plans for the comprehensive plan. And I'm inferring that he went and talked to them or sent them the site plans or summarized the site plans. Would that fall within his authority to consult with external agencies or I think the official language is to like consult with agencies or staff? Would consulting the town council concerning the action that they then took, I don't know if I can say that that was an error or if that was within his scope of authority as the zoning administrator. Yeah, there's a lot of gray. So I'm not laying
I
down.
don't remember any documentation
Yeah, I don't think there
by
was.
that.
I don't think there was. Did you say there was?
I remember reading something about that, but I have to go and see if I read it. Did you hear that? I just said that I remember reading that. I just would have to go back and look where that actually was written.
Can you summarize what you remember from that, and we can?
Just one of the steps that they go and consult with whatever. I mean, you have multiple plans to be looking because you have to consult with multiple people about what's happening with the plan, right? In general. I don't remember what I read at the moment. But do you believe that that moment in that letter that was written was a pivotal moment? And I know Blitz called it a pivotal moment. He said it was the beginning of a so in that regard,
The beginning of the what?
refusal, right? Too much stuff. So, but would you then think it was an error because of timing, because of obligation to look at it, to what? What would cause that to be an error? And I'm wondering because I know that the 60-day mark that was brought up in this case, that they were obligated to fulfill their duties within 60 days, that was for critical areas. And I still am not convinced that that actually pertains to all Site 1 plans. Because in the general provisions, it does not have any type of time frame associated with it. And to think that those plans within a critical area had a deadline that was more so than others is kind of strange to me. But I just don't know if they
Yeah.
were, at least all 5 of them. I don't know if all 5 of them were required to have that.
No.
Yeah,
I
the
don't
the
think so.
timing seemed like
But-
maybe it wasn't a strict. Yeah.
You know, but there's another aspect to it in that there's a 60-day time limit. The moratorium was imposed before that 60 days expired.
But
The-
was there a 60-day time limit is what I'm wondering about.
code-
I don't,
The code,
see, I don't know that it's that clear.
I didn't read that the six. My read of the code was not.
Section 290-25 clearly says to me that the commission must decide on a site plan in the critical area within 60 days.
So if you look at the entire, if you look at the chapter and you look at this Article 6 in its entirety, everything is broken into Site 1 versus Site 2, Site 1 versus Site 2. So I think that interpreting it, yes, it does say in that statement, it does say that they shall approve a site plan within 60 days, but it's also what is it that they're referring to in there? And if there's ambiguity in that, I'm not saying that I need to be the person that determines that wording, but if you have a Site 1 plan that's not in a critical area, and then you have a Site 1 plan that is in a critical area, to say that the one in the critical area needs to be processed within 60 days, but the one that's not in a critical area
Yeah, I didn't.
doesn't have a time frame, that doesn't make sense to me. I just don't think that it's all inclusive because it's only within the critical area section. And each section divides it between category 1 and category 2. So I personally still do not believe that this is the absolute interpretation of this piece.
Even if the 60-day limit did apply, technically, because the moratorium was put in place before the end of the 60 days,
Mhm.
technically, there was not a violation. Because once the moratorium was in place, I don't think the administrator or the commission could do anything.
Yeah, I think you could. I mean, not to. There's a lot of coulda, woulda, shoulda things that definitely could be argued here, but I'd have if let's just say hypothetically that the moratorium was passed and then planning and zoning got up behind the lectern and said these plans are denied due to the moratorium. I'm not sure if I could find an error in that.
But I don't believe that happened.
It didn't happen.
Right.
It didn't happen, right? That's the, like, there's kind of like this implicit decision that was made by having a moratorium that shortcut that, I don't, but maybe that's, yeah.
I mean, because of that, the moratorium was put in place before the end of the 60 days. I don't see an error of interpretation. It was certainly an action, I believe a decision by the administrator not to process the plans in anticipation of the moratorium.
Yeah,
But, he had 60 days and 7 weeks went by, it didn't get processed, but then bang, the clock stopped. So technically, I don't see an error.
yeah. And an error on behalf of,
Yeah,
The zoning
it's
administrator.
a narrow reading of it. I realize, but also, I don't know if I can, council indicated to me in a conversation that the 60 days isn't a hard deadline because there's no penalty stated in the code. And do I
What I
understand
said
that
was,
correctly?
what I said was that it could be argued that the 60 days was directory and not mandatory because there was no sanctions for failure to comply with that 60-day time frame. Now, I'm not saying that's a correct interpretation, but it certainly is a viable interpretation.
And it doesn't, the same thing applies to other site plans, right? There's the code doesn't have a time limit, an explicit time limit for non-critical area site plans. But then it also doesn't say, well, I mean, I guess it's a judgment call. It has to be, the plan should be reviewed within a reasonable time. There's no definition of that in the code.
So in the event that there is not an obligation to have a time period associated with it, was the letter from Jakubiec at that point, then the question would be, is it a decision? And was that decision, could it have been attributed to error if there was no timeline associated with it? Right? I'm just looking at it
Yeah.
both ways. Since that's the point, but
I mean, yeah, there's so many directions. I mean, it's like they submitted their site plans and didn't get an approval or denial. They got something that looked like a denial. This like wasn't official, didn't have signatures on it. I don't know if it matters.
No, I don't agree with that. I don't think you could call it a denial. It
What do you
just
think?
could not, yeah, I don't think I could call it a denial. It's just a lack of action.
Okay.
Not a denial, not an approval.
Yeah. I mean, yeah. I don't really want to devil's advocate the whole thing, but
okay.
So, I mean, getting back to decision points, the second decision point was when the moratorium was lifted.
to rehear to reopen this again, the site plans as they were submitted.
Site plans, the review of the site plans was not picked up. Now, was there an error involved there? Error of misinterpretation of the code? Was there a decision not to review the plans? That's a little less clear to me.
Can I throw another wrinkle in?
Go for it, yeah.
So, Jakubiec's letter stated two things, though. It stated that it was an undue burden to the commission because they were in the middle of the comprehensive plan. So when the comprehensive plan was approved, is that a point? Because, I mean, this really, that letter, if that is the beginning of the refusal, was two pronged. There was the comprehensive plan plus an upcoming moratorium.
Which one?
Jakubiak's letter, Exhibit 7, the February 5th letter that said, hey, this is too much for us to do. So there were two things that happened there. So in my opinion, yeah, I made note that the comprehensive plan was approved later on, and that could be.
Remember what date that was?
My notes say April 21st, 2022. April 20.
Comprehensive plan
Mm-hmm.
was 4/21.
22.
Yep.
Mhm. So just to throw something else in there.
Thanks.
Um,
I mean, like, I still, like, I feel like it all still comes back to the first event of not, of, of making a decision not to approve or deny the initial thing, to kind of put it in this gray zone. In which then led to the second point, which is, since it was neither approved or denied, is it still open and should be reopened? You know, I feel, yeah.
But I think part of what's getting me about this is that the error is stated as a continuum, that it is from January 29th, 2021 till the date of the appeal. So can an error occur over that time period, or is there a single event in which we are actually talking about?
So I was thinking about this one today, and I came up with an example, and I'm gonna use our legal counsel, and I'm gonna say, Fred, you can holler at me if I get this way off. If I'm gonna do a crime, I'm gonna extort Fred, right?
Extort me?
I'm gonna extort you, and I'm gonna say, give me a bucket of money, or I'm going to the cops. The harm and benefit would be ongoing. You'd be out of your money, and I've got it. But if this ever goes to court, I think if it's a statute of limitation things, I only extorted you on one time, right? It's not like an ongoing extortion. I have your money, which is the harm, and you're out of your money, or sorry, you're out of the money, which is your harm, and I have your money, it's my benefit. But that still doesn't mean it's an ongoing thing, right? It happened one time. And I think that means, I don't know, in this case, it would be that decision point was the thing that would set something like a statute of limitations, where even if the harm and benefit are still ongoing. So I guess that's a roundabout way of saying an example of how I don't really buy an ongoing event, that the harm is ongoing, but the event itself happened on either the date that Jakubiak sent the letter back or the date that the moratorium was passed, however you want to, whichever time frame you think was the decision point there. I think that's the event, right? So that maybe says that it doesn't reopen if in the second inflection point that you're talking about. I don't know.
Well, the question is, when the moratorium was lifted, should the zoning administrator have picked up review of the site plans? He didn't. Should he have? There was a lot going on, right? The comprehensive plan. Well, actually, the comprehensive plan had already been passed. But there was a lot of change. There's a lot of code changes that were occurring. Ordinances being passed to implement it.
But they had already returned the fees and for all intents and
Right.
purposes believed it was done. So what were they supposed to pick up at that time?
Well, that's a good point, because there was formally no application in place.
I think that one's fairly easy in that it shouldn't have been, I don't see an error in not picking it up, because from the administrator's perspective, the issue was closed, the event was done.
There was an attempt by the appellant to have the plans reviewed during the moratorium. And that was rejected, if I remember correctly. I may be misremembering. There was an event. Maybe it was an appeal application. There was an application for the appeal submitted in 2022 while the moratorium was still in place. Yeah, I believe that's what I'm thinking of.
So yeah. Yeah, because the appeal application was filed June 24th, 2022.
Right.
So that's what you're thinking of, right?
Yeah. I remembered an attempt to have the plans reviewed, or a request to have the plans reviewed
So
sometime after the moratorium was lifted.
So, I have in my notes, the comprehensive plan was approved April 21st, 2022. On May 20th, a month later, Blitz wrote a letter to Planning and Zoning Administrator and Commission to have the plans reviewed. It was
Okay.
that letter that was the response 2 days later came from Pounds. And he CC'd Wall on that letter. I have it in here somewhere, which exhibits they are. But there was no indication in that letter that he was speaking on behalf of the Planning and Zoning Administrator, nor the commissioner or commission. And so he responded, and that's when he's like, "Oh, it's indefinite." So that happened. And then, so then June 3rd, Blitz wrote another letter to Pounds asking who that letter was on behalf of, and no response was received. 3 weeks after that, the appeal application occurred.
Okay. So two events. What was that first date again?
Of which the letter that requesting the review,
Yes.
May 20th, 2022. So that's actually in this timeline right here too. Mhm.
Right. Okay.
So in my opinion, that's when, if we're saying that the moratorium expired, what's a pivotal point, whatever else, because in order to file the appeal, you have to have your concern brought up with the Planning and Zoning Administrator, right? So that could have occurred after the Jakubiak letter in February 2021, right? Or it could have occurred at that point too, when they wrote back and said, "Hey, what's going on with this?" and got no response. I think that lack of response could have been a response too. If we feel that is a date, right?
Is that the third one we've got so far? We have the initial response on 2/5/21.
Oh, so there's another aspect, another point to that is that, refusing to pick up the review of the plans in May of 2022. Was that an error on the part of the Planning and Zoning Administrator? Did the
I-
Planning and Zoning Administrator,
Was he obligated to?
was there even evidence that, because the response came from the town attorney?
We have, and it's my opinion that we were given no evidence to say that came from planning and zoning in any way,
Right.
shape, or form.
Correct.
So we cannot know if there was any discussion or whatnot. From what I have seen, I see no indication of that.
I mean, I would be unable to rule that I would say that that's out of our bounds because it was not an action by the administrator or the commission.
Unless the inaction was an action.
I love that question.
But if the administrator or the commission was not involved in that rejection,
Right, well, you could have that letter was a rejection, and you can also have that, the fact that it didn't come from planning and zoning,
right?
that they rejected it in the fact that they chose not to react to it. And coincidentally, the town sent something too. So to me, that wasn't done on their behalf because Pounds represented the mayor and the town council, and that letter did not CC the planning and zoning administrator or anybody.
I agree with that. That's
So
also so is that something we could rule on, a refusal? I think that's outside our bounds.
but the fact that a letter was written to the planning and zoning administrator, unless mail fraud occurred, yeah, he received it. We just didn't hear anything from him.
I think you said,
I said that if a letter was sent, unless mail fraud occurred or something, the planning and zoning administrator and the commission still received the letter. I would hope that they still received the letter. That being said, we didn't receive something before too, so I don't know.
This is the May 2022, the letter asking for site plan review after the, right, in the, yeah.
Let's go back to March of 2023, when the moratorium was lifted. And the review of the site plans was not started. Is that an error? Is that
It's kind of,
something we can rule on?
I don't, I mean, so what they have, I have this in, this is the timeline pulled from the code, which would be that the, let's see, in November 22 is a zoning amendment, zoning map. Then March of 23 is the termination of the moratorium. So even then, and along on the same date of March 23, there's an additional zoning amendment that passes. I mean, those site plans are going to apply to the old rules, which is kind of the whole reason we're here, right? I can't see that as being a decision point because those are so out of whack, right? Those we haven't looked into the differences in zoning, and I don't think we should. But the idea that they could pick up 2-year-old site plans with a new,
Certainly you can, if you decide that you're going to review them against whatever,
new plans?
whatever code is in place at that moment.
I mean, you could. It's a bit of a stretch for me, but
Well, you know, it wasn't, I mean, there wasn't an explicit request at that time to review the plans against the code of 2021. It would be like submitting a new, let's say you submitted the plans fresh in March of 2023. Those same plans would get reviewed against the code that existed at that moment.
yeah. I mean,
But the point earlier, I think, is a good one in that although the plans were there was not a formal application in March of 2023 to have the plans reviewed.
I don't think they'd be, yeah. I can't read into that.
I have a question. How can the error occur in March of 2023 when the appeal was filed in June of 2022? You can't have an error
But it
occur
was-
9 months after
but-
it says up until this point in,
But the
Application.
appeal application was rejected. So it
Well-
there wasn't any appeal.
but all of this is a continuation of that.
Well, why we're here today.
Again, the moratorium was still in place.
Yeah.
I don't think the zoning administrator or commission could have done anything while the moratorium was in place.
I think that's,
It was only when the moratorium was lifted in March of 23 that there could have been any progress.
but I think the applicant would
The fact that
argue.
there was not any progress, was that an error? Was that an error of interpretation? I mean, we're trying to rule on the actions of the zoning administrator and the commission, or decisions of those bodies.
Are you gonna clarify, or are you gonna?
I'm trying to clarify on my own.
No, you're not.
I'm struggling that the appeal application was rejected in 2022, but not by us. It never got to us.
Hold on. So we're talking about the appeal to come to before the appeals board, the request to come talk to us.
Yeah.
Okay, no, sorry, just to clarify.
Because that was, for failing to process the site plans. I don't know. There's just,
Well, once you file an appeal, review of the site plans is put on hold. Well,
I understand.
Actually, I guess, I don't know if it has to be put on hold, but I think normally you file an appeal and any further reviews get put on hold until the appeal's
Or
heard.
no permits or anything. Yeah.
But again, I think the clock doesn't restart until March of 23.
I don't think. Yeah. To me, there's only one decision point by zoning administrator and planning and zoning, and that's the first one, which is the Jakubiec response letter and subsequent files. I don't think that there's a whole bunch of mess with the moratorium and all that, but I think and there's a lot of coulda, woulda, shoulda in a lot of directions, but I think the only one that really just stands out to me is, did Mr. Jakubiec make a mistake, an error according to the rules by which we're guided in February of 2021, or roundabouts there. And I think that's kind of why I was talking about all that domino stuff at the beginning, was because I think what the applicant would like us to do is find that was an error, which then knocks over some things which are outside the scope of this board.
What do you think was happening in March of 2023?
It's more that I don't think anybody, reading it, I don't think anybody wants that. It's like these site plans were submitted lawfully on a date, and they were planned for that specific version of the law and the zoning code, and anything other than that, I don't think is
That's the starting point.
the starting point. That's the
Your
only
argument.
point, because if they, let's say that got reopened after all these zoning ordinances, I can't imagine that the applicant would be terribly happy with that. Probably would end up with another appeal.
That's really not the point. The point is that, should the plans have been reviewed in March of 2023? And I guess there was no formal application,
To me, the answer is
In place.
pretty clear no.
not whether they would have been rejected because the zoning code changed. And that's not pertinent. They may well have been rejected because the zoning code had changed, but the fact that the review was not restarted at that point. And there was no formal application made. You know, the only formal application to review the site plans was 2021.
I think that as you're continuing to discuss and deliberate this, if you find, or get to the point where you think that that 2021 email was a determination, then one of the other things you need to consider is whether there was a timely appeal from that determination. Mr. Chairman, can I ask for 5 minutes?
Yeah, let's take 10. We'll resume at 7:30. Yep.
Like those?
And in fact, it's Jamie, it's David's, the skin that we have learned and Sharon. We go down and she's 69. But yeah. You can go.
Was it there?
I'm thinking.
I got the, like the guy said, quite short is 6'5". If I was saying, so somebody saying, with like privacy features, I just stick out of the top, like. Scared you. Sit down.
I feel like I'm looking at.
Oh, did you go to the Arctic or the Antarctic?
Antarctic,
Antarctic, okay. I thought that's what it was.
December. It was a trip. Kind of a bucket list thing.
Yep.
I had 2 opportunities to go and I passed. One was graduate.
Tell you what, it's far away.
Yeah.
Takes a long time to get there.
Did you go to like Argentina or Brazil?
Flew to Buenos Aires. And then spent a night in Buenos Aires. Then flew down to the southern tip of South America. And got on a cruise ship.
Check you out.
I was sweating. Because you're wearing 3 layers. Had to climb a steep snowbank to get there. To get to this point. And I'm carrying this 50-pound camera with a big long lens.
But you got a cool picture.
Yes.
So. So is there anything that says we?
No. Is everybody good? Yep, turn your mic back on if you would. All right, we are resuming after our short break. I think you should feel free if there are things that, like, this is very much a like, just get it out if you want to. There's things on your list that you'd like to talk about, even if it's not necessarily in the context which we, kind of centered around a couple things. If there's other issues you'd like to chat about before we. I don't really have an agenda for where we go from here. I think at some point we'll want to walk through some of the specifics of were these particular, can we check these boxes in terms of process? But yeah. Do you have anything, Amy, you want to go?
Totally random. You were asking before about who Jakubiec would have given those plans to. You were saying when, it takes time, once the administrator gets the plans, but doesn't he do something with them? He talks to people, whatever else. So the processing procedure after submission, it says the administrator shall review the applications for completeness and will refer the applications to the appropriate individuals for agencies for review, comment, approval, etc. So whether he started that process, I don't know, but I'm just saying that's where I read
Yeah.
that.
Yeah, and that was my read on it, was that even though it doesn't, that maybe sounds like talk to state agencies or whatever it is that is in the purview of his job, that talking to staff for the town council would also fall into that. That was my read on that particular.
But I think we have to keep in mind, at no point did we actually hear from Jakubiec. So we have no idea if beyond things such as that letter, we have no idea what communications actually occurred, whether with anybody in one of the parties or otherwise. We don't know. So I think that's something that's really important, that we only have part of that picture.
So let me bring up another point. Let's say that we decide that there was a misinterpretation, there was an error on the part of the administrator or commission. You know, a decision resulting from misinterpretation. The appeal asks that we request the administrator to immediately commence the processing and review of the site plans according to the zoning code that was in place in 2021. Are we able to do that? Is that within our powers? Because if it's not, then whether or not there was an error is irrelevant.
I think we'd still have to do it.
Do what?
To make that decision, even if we didn't have, I think we'd effectively be a speed bump in a different legal battle, which is that we can make our decision.
But if we decided there was that there was an error, request the administrator to immediately pick up, review the site plans.
I think that in order to do that, though, we have to find that not only is there an error that was an appealable offense, but that the appeal was done properly and everything leading
Well,
up to
let's
that.
assume that we decide that it
Everything good.
was.
Okay.
Premature to
If
have that.
we don't have the power to request or tell or order the administrator to review the plans against the code that existed in 2021, then there's no point.
There is a bit of that.
We would have to deny the request, deny the appeal, because if we don't have the power to ask the administrator, order the administrator, whatever, to go back and use the 2021 code, then automatically we'd have to deny the appeal.
I don't know if we'd have to deny it. I think we could make a decision without any enforcement. We ultimately don't have any enforcement power. We are a second review of the powers that exist for planning and zoning and the zoning administrator. I mean, I think some of the requests were for us to do some of the work that other folks within the town do was a little too far for me, but I think we'd be well within our powers if all of the if we go down the list and we find that all the requirements have been satisfied and that an error was made, that the role of the board would stop as soon as we made the decision that an error, like that this was an error on behalf of planning and zoning and the zoning administrator. I don't think we want to go any further than that.
But again, the request, it's
Yeah.
a two-part request. Request that the administrator pick up, review the plans, and that the plans would be reviewed against the ordinances from 2021.
Yeah, I mean, if
If you can only fulfill one but not the other,
I could see a scenario where we'd say yes to both of those. That is how it should have been. We'd be effectively winding back the decision clock and making that
so
decision.
we say yes, and the zoning administrator says no.
Like, I don't think we have, from the point at which we say that this is how the decision should have been made, I think we kind of can wipe our hands of it. We don't have enforcement authority.
I'm not sure I agree. If we decide there was an error, do we have the authority to, what's the wording? there's a difference between a request and an order, right? The application asks that we order that the zoning ordinances in effect as of January 21 be applied. The request is asking for an order from us.
Yeah.
So you don't have to grant the specific relief that the applicant or the appellant has asked
Right.
for. You have the discretion to grant other types of relief.
Okay,
I view it like a variance. If somebody's asking for a 20-foot deck and we give them a 6-foot deck, that's what we write that we are going to allow. And then it goes to the other powers that be. And after that, it's out of our hands. And so just because that request came in doesn't mean we follow through with it as written. Is that fair?
I think we'd just be saying that an error happened and the remedy that we'd recommend would be these site plans be considered as of the date that they were filed against the town code and the zoning map and all the other things that apply at that time. I'm not saying that's what we should do because there's lots going on. But I think if we went down that road and found an error, just us determining the error would be where we stop.
Assuming that you find that there was a timely appeal.
Yes, all of
All of
the
the
stipulations have been met, and we find that. Yes.
the appeal needs to be filed within 30 days.
Got a whole list of them here. I don't know if we want to jump into that thing here.
Well, there are two statements. There are two statements, though, that say that. So it was in the wasn't it just like in the critical area or something, but that was stated. It does say 30 days, but it also states 5 days.
Sorry, what are we talking
I
about?
understand that 5 days only applies to plan reviews or, yeah, I picked up on that as well. There's a 5-day.
Here we go. I have
limit
the
specified, a
two.
30-day limit,
One is 29023F.
right,
Which
okay,
is-
so,
You want me to read it?
go ahead.
Was an appeal made to the Board of Appeals within 5 days of the decision? That's 29023F. And the 30 days is was an appeal made to the Board of Appeals within 30 days of the decision? And those are probably two different subsections.
My understanding is the 5-day limit regards a decision pertaining to some aspect of the site plan. Because it's under the section,
Under general
It's
requirements.
just site plans, general requirements, section F. Any person aggrieved by the decision
on a site plan,
of a site plan,
And general
Yep.
requirements. yeah.
general requirement of site plan,
all right?
made under this article may within 5 days of such a decision appeal to and have a determination made by the Board of Appeals. So that's the 5-day one. And then,
And there was no decision made on a site plan.
well, that's what we have to decide. Was that in this, what we were talking about before, is the February 5th, 2021 letter, was that?
My reading of that is that, for example, the administrator looks at a site plan and says, this dimension is not acceptable. Therefore, the plan is rejected. That's the 5-day limit. But that doesn't apply in this case.
I think that's an interpretation.
Well, yes.
But I mean, it could,
Here's the second one. The second one is under subsection J. Let me find the total title so I can actually tell you what we're talking about. This would, subsection J specifically for the Board of Appeals. So if you're reading that, you might say that the specific subsection for the Board of Appeals is the date that applies because it's more specific than the first. And this is under Section J, Rules and Procedures for Filing Interpretation and Variance Appeals and Special Exceptions. Everything. And this under number 1, General Rules and Procedures for Appeals and Applications. And this specific language is any appeal should be made within 30 days after the date of the administrator's decision.
23F.
Mhm.
See what it actually says. And I don't think it was as narrow as Paul suggested. Any person aggrieved by any decision made under this article, and that's the entire site plan article, Article 6, may within 5 days of such decision appeal to and have a determination made by the Board of Appeals. During the period of appeal, no building permit shall be issued.
Okay, so we got 2 different time limits.
Yep.
Which ones apply?
It's the more specific one, which would be the subsection. This one, the one Fred just read, is in zoning general requirements. The second one is specific to appeals. I guess this one has the other word appeals in it, so.
Determination made by the Board of Appeals.
Determining, right. Yeah. You said you wanted to go through the rules, didn't you?
Yep.
I mean, we're outside of both of those either way, right? Like this, if we're going back to the specifics of this case, would be like these, like if I'm summarizing in human terms, this request was kind of left in limbo. It was neither, I mean, so the letter gets sent back, whatever, we can, whatever. It's neither appealed nor denied in an official capacity. It's in this gray holding zone. I don't feel like we can apply any limit date to that because it's kind of unfair, right? Like we're just going to hold your applications for 5 days and neither appeal nor deny them, but then we're going to hold you to the date at which we sent the letter or something, something. It's like, yeah.
I agree with that sentiment.
I might take an argument something more along the lines of in official capacity, the moratorium passing was in effect a denial. I'm not saying I'm making that argument, but I would hear an argument along those lines where here's something official that happened with a stamp on it. It's not by the
Planning Commission or by
Right.
the zoning administrator.
yeah.
So I feel like, yeah, I feel like if there's any date later than that, it would be, if there was a 60-day application period or whatever, right? A denial and a lack of response, whatever else, and if that 60 days passes and nothing happens, then that would be another potential, but nothing, no appeal, no anything came of that. So, I mean, we could do the opposite and backtrack, is to make this, if it was timely, when would things have had to have happened? But we have already eliminated that those were
Like-
options.
Yeah, I mean, who do we apply the rules to, right? Like there are 2 cases where in order for the date to start, we'd have, yeah, it's not really fair.
But in order for the appeal date to actually hold with either one of those, it doesn't, I don't know that it even holds water with some of the later things.
I'm sorry, what was that?
I was just looking to see if it would even hold water later on with some of the other events that we spoke about. But we didn't believe that that was anything having to do with planning and zoning. So that would be a no.
Was the check being returned? Was that an act of planning and zoning or? Right, like they submitted an application, money was refunded. Would that be considered an application of, or not? I'm not,
Denial or
a
whatever.
denial, like
Decision.
decision?
I would say yes. I mean, it came from the town administrator, but it came from the town administrator after the planning and zoning administrator said no. So to me, that is part of that. But to me, that's also part of his letter, even though it's technically a different date.
But that was not a, that was not a rejection on the merits of the site plan.
I think it's still lumped in with that February 5th. All right.
I mean, I guess in terms of determining if an error happened, was there an obligation upon receipt of these to perform a series of, right? Mr. Jakubiec gets filings. Does he then, is part of like, does he need to complete a series of steps in order to have, I don't know. Never mind, just talking out loud.
I mean, we can debate different things, different steps like that, but does it ultimately matter? If we believe that a decision point was made at that point or anywhere
The latter time.
in that time frame, right, that he could have done that, does it matter? Because what happened after that
Yeah.
in a timely manner? I don't know. I don't see the utility in looking at that since we need a set time and that's the only one we can find.
So do we want to just run down like I have a list of kind of general process things and specific ones. We already talked a little bit about the specific ones, but like maybe this will, I don't know if this will help anything, but start on the general ones, which is, the first one is, was this offense appealable? These are just notes that I have from some of our legal discussions about process issues.
What would make it not appealable?
If we found that there was not an actual error, if we found
We followed
He
all the,
followed-
Well, that's a different question than whether it's appealable. It's always appealable.
If
or it would be made appealable by being a decision of planning and zoning or zoning administrator. And what else, right?
did it involve an interpretation?
290.
Ordinance?
Right.
That there was an error in an order, requirement, decision, or determination made by the administrator in the enforcement of the zoning chapter or by the Planning and Zoning Commission. So these are all, I think, preconditions to something being subject to appeal.
It has to be an action or decision on the part of the administrator or commission.
involving
the
zoning.
interpretation
Right, right.
of any provision of the zoning ordinance, or where it's alleged that there was an error in an order, requirement, decision, or determination made by the administrator in the enforcement of this chapter or by the planning and zoning commission.
Keep on discussing the next one I have noted down is was it timely? And I think that's one where we're gonna have a hard time. I think that's kind of what we were just talking about. 35 days, 30 days. I think gray zone.
I don't think it's gray.
You don't think it's gray?
It's gray.
Okay.
I think it can only be gray if we don't have a specific time that we're associating with. If we think there is a time, and it's a black and white issue that when it was filed, what happened 30 days prior or 5 days prior, whichever one you look at, was that the point
Around
that we're
that.
talking about that? So it's a black and white thing. Once we've determined a time in which we think this error occurred,
It decided that February 5th of 2021 was the decision point. Then the argument would be that the appeal had to be filed not later than March 5th of 2021. What you're saying? Clearly it wasn't,
I think
but rejecting an appeal on that basis, makes me very, very uncomfortable.
Yeah.
I don't believe that gives the appellant a fair hearing.
This one's gray to me because of the holding pen that the applications were put in. Like
Holding
this
pen.
holding pen where it was neither approved nor denied up until some different event, if you want to argue that. Like I wouldn't feel good making a determination based on
And that
timeliness.
February 5th email didn't make it entirely clear. I mean, it didn't come in right out and say, we're not going to review the plans. It was vague, right? Well, it's a burden. There's a moratorium going to come up. But the message did not say, we're not going to review the plans. In other words, I mean, it wasn't a hard point at which you could start a clock to count for 30 days.
That's how I feel. Like the timeliness question is maybe a requirement of what we have to do here in order to lay down a decision, but I don't
think that question about whether the appeal was timely, I don't think that's an important question.
I think it's a really important question. I think that's exactly why we're here,
like we'll have to address it.
because it's written in the town code. Yeah, that's
The board can only entertain appeals that are timely filed.
I mean, we could want to allow things, but that's not in our purview to do that. So to me, the only way that this is timely, right? So it was filed on June 24th, 2022 was when the appeal was filed. So going back 30 days, it's what, May 25th, 2022, because it has 30 days, say the 24th. So that is 2 days after Pound's letter saying that the moratorium was still in effect, and 4 days after Blitz wrote asking for the review. So there was the request for it. There was the denial by Pounds, which we are saying is not by planning and zoning, right? And then 32 days pass and an appeal is made.
Okay, we're talking about a couple of different time periods. When did the clock start on this 30 days?
How about
So I mean, though,
how about we take this one and table it? I don't think we're going to get to an answer tonight, but why don't we put this on the list of things to think about before we get back together again.
Do you understand what I'm saying? If you're, if a person has 30 days to appeal it, and the appeal happened on this date, what happened 30 days prior and in the midst of that? So I think that's,
We can, yeah, I think,
I think that's what we have to look at. If it is timely, that's the only time period we have. It was that it.
let's get our thoughts together on this. Like, I think I've heard what you said, Amy, and we can consider how we think. 'Cause I don't think we're going to wrap this one up in the next, number of minutes. This is just it's a thing to put a pin in on and lay out what you think, and we'll come back together next time. And this is one of the explicit things we can talk about.
So you're suggesting that the clock started in May of 2022?
I'm not suggesting anything. I am saying that if the timeliness is the factor or requirement of an appeal, you have an appeal application that has to be filed within 30 days of the error or the interpretation, right? So you have a calendar date right there that limits that time period.
It's just, yeah.
Well, another thing too is it wasn't actually filed because it was never accepted.
You mean, I think the date, that one, you mean the appeal to us, the paperwork for us.
Right,
Yeah.
that's-
When it was received by the
to
town.
this-
Yeah. This one's a hard one for me.
There was an attempt to have an appeal. There was an attempt to submit an application for an appeal, and it was rejected. It wasn't accepted.
Rejected?
Well, we never got it.
You never got it, but I think that there was an appeal filed in a proper form with the filing fee. Everything that needed to be done to perfect an appeal was done. Whether it was from an appealable decision, whether it was timely, those are different issues. But I do think that there was an appeal filed. Now, it never came to the board for scheduling a hearing. You guys never knew about it until after there was a judicial determination by the circuit court saying, Board of Appeals, you have to hear this case in a timely manner. Now, I don't know why this board did not know about it, why it wasn't presented to you, but that's not, what we're here for.
Yeah. Yeah, let's come back let's get our thoughts on that one and come back. The next one, I think, the next couple, I think Fred already hit on with under the appeal, but was the offense appealable question, which was the first one we talked about. This is, was it a decision of the zoning administrator or planning and zoning commission? So whatever it is we're considering here was a decision we already talked about. Keep on. Does it involve interpretation of 290 zoning? Does it involve enforcement of 290 zoning? The answer to those is yes, but regardless of which, yeah. Okay, I'm just going to pitch this out here. I feel like we've maybe run into a little bit of a wall. Does anyone have objections with wrapping this up 30 minutes earlier? Would you like to continue working through this together? I can go either way. There's plenty of caffeine.
I guess my question is, if we stop it now and pick up later, what progress will we make at the second meeting?
Ultimately, I don't think, regardless of how fast we go in the next 30 minutes, we're going to come to a clean conclusion. I think there's, at least for me, there's some things I'd like to lay out specifically on the timeliness question. I guess I feel like it's stalled a little bit here and that we would all benefit by getting our thoughts together as to how to continue to narrow our discussion. But that said, this is a little bit of a strange scenario because it is public and you feel like you don't want to ramble. You want to get your ducks in a row before you talk. But sometimes you just have to talk it out, right? So yeah. How do you feel? What do you want to do, Amy? Personal preference.
I mean, like, I think that we have to meet next time anyways. I think, and I think this would give us time then to evaluate, the June 2022 appeal, the timing, whatever. I think that we could have more clarity in our conversation if we did that.
Let's. Sorry, Paul. What do you feel like, Paul? If you have a preference to how you'd like to proceed right now, what would you like to do?
I don't know. I hate to give up this. So, I mean, I don't know if we're making progress,
I hear you.
but at the same time, I hate to give up the time.
How about this? I feel like yes. How about we look at your timelines and let's just lay out the times when we'd like other board members to consider things. This may be one time frame. Can we narrow this to an action or series of actions? It sounds like we've maybe kind of informally done that, but explicitly, do you still think we should consider the reopening after the moratorium expired as an action to continue talking about, or have we reached some?
I guess I'm reconsidering that.
We can, okay.
But let me go back to
Okay.
the 30 days prior to the filing of the appeal on June 24th.
Mhm.
What event happened within those 30 days? And the only one I see is a letter from Todd Pounds on May 25th. So would we say that May 25th, 2022 letter is when the clock started on the 30 days?
I think that the assumption would be that would be the clock as far as when the appeal was made. So we need to determine if that is a date that would allow that appeal.
I'm not sure what you mean.
Well, we said before that we believed, well, I thought it was kind of all of us. It was, if we believe that letter was on behalf of Planning and Zoning Administrator and Commission, then that would be a moment in time that you could then appeal to because it was a decision. However, our prior conversation, we all were kind of speaking to the point that we did not think that was on behalf of the Planning and Zoning
Okay.
group. So I think that could be what was the basis for the appeal application. But I think, and if we had more, a couple more days, whatever else, we could then really look into it and see if that's what we thought it was. Are we missing something else that happened in the days after? I think it was the 25th of May. I misspoke before.
So if we decided that,
Exhibit 33.
if we decided that letter on May 25th was not on the behalf of Planning and Zoning, then the clock didn't start, and suddenly an appeal appears. There's no clock running, suddenly an appeal appears. What do you, where's
To me, that's
the
not an
30,
appeal.
where's the 30-day rule applying.
Right, and that's why, one reason why I think having it, if we wait until the next session, then we can wrap our heads around that and really dive into it to see, was there something else that we're missing? I don't know if anything off the top of my head. Mm,
So the three dates we have noted down here as, oh, sorry, are you? Were you gonna?
Go ahead.
I was just gonna, just for our own, what we do once we're thinking by ourselves is the inflection points are the initial Jakubiec letter in February of 21. Paul has made has had some thoughts about 5/22, which is that the, maybe I wrote that date down wrong. Was that the date that the moratorium expired? No. Why did I, sorry, I wrote the wrong date down for that.
May 2022 is what we're talking about right now, is
That's
Pound's letter.
not, this is the Pound's letter.
May 25th.
May 25th.
Maybe one at the extended moratorium expiring on, what date is that? Termination of it in March of 23. Are there other dates or other things that you can think of right now that we should consider while we're not in session?
I think the way to handle this, to, in order for us to come to a conclusion, is we come up with a list of relevant questions. We agree as a board on the answers to those questions, to each question. And whatever those answers are, once they're put together, it becomes our decision.
I'm going to caveat that by saying that I'm not sure that we have to all agree on everything. I think we have to agree on an ultimate decision, but I'm not sure that we have to agree on everything.
You know, I think coming up with those two questions will help us focus. A specific list of questions to help us focus.
Can I be a devil's advocate? So I think that that's a very likely scenario, but I think that we have to also know that in an event like this, not everybody's always going to agree, right? And so it could be that our decision relies on the fact that we can't agree on it. We just have to leave that open, and it might be frustrating as all hell for everybody here, but that might be the result. So just, we're going to try to, have this conversation and all come to the same mindset. But I'm just throwing that out there. Because that's part of us.
Well, I mean, how else? So what other approach would you suggest?
Oh, no, I
Other
think
than
I
that.
think our approach is good. I'm just saying that I think that, this situation, there's only 3 of us. And I think that there's a pressure that we all have to agree. And I think we all want to come to the same conclusion or whatever it is, right? Ideally, that's what we do. I'm just saying that doesn't always happen. If we had a full board, it might be a 2-3 vote or a 4-1 vote or something.
Right. Sure.
But so we might not all agree. And when you say
Understand
answer
that.
the questions. Okay, that's all I'm saying. I thought you were saying
What's going to help us come to a I don't want to say come to a decision, because all 3 of us may not agree. But what process is going to help us to finish the conversation?
So I think we've already, like, not to maybe to over recap of what we've done, is there's a lot has been presented, a lot has happened. And from where I sit today, I have not heard anyone make serious arguments that we should be considering anything about a moratorium or resolution other than the start and end dates. It doesn't matter the interpretation of it, the legality of it, that is outside of the scope of this board, which I think is a massive thing taken off of our plates for the next two meetings, because that we're not discussing the legality or any issues regarding moratoriums, ordinances, resolutions. We're saying there was a moratorium and it ended, but nothing kind of in between about the specifics of that. And I think taking that off the table has been a pretty big win, even from this first session. I mean, unless someone has real disagreements with how I just summarized that, I haven't gotten any indication that we want to turn in that direction. And once we've done that, we've now gotten to only a couple things that we actually are going to consider. Some of them are procedural process, timing, and checklist issues. Some of them are what are the important inflection points which we should discuss. And I think, I mean, from where we started here, that seems pretty narrow. And I think we keep doing this. Go
When
ahead.
you use the word, when you say process,
Process, yeah.
are you talking about the process that will get us to a decision or
Talking about the,
the sequence of events that occurred?
I'm talking about the checklist of things that we would need to go through to say that these things that we are kind of, when I say process, I mean the things that we already kind of went through. Is it appealable? Is it timely? Was it a decision of the zoning
Those are
administration?
questions.
Those are questions. Those are process
Those
questions.
are questions.
Yeah.
You
Yeah.
list those
Yeah.
questions and we each say, on each question, we each say yes, no.
I think that's the way.
And that's what I was getting to.
Okay, I thought you were saying that like, we all had to say yes to those questions,
No.
like to the same
No.
question. Okay.
Yeah.
But
Okay.
yeah.
I think
We come up with a list of
Yeah.
questions first. And then we debate each of those questions. And hopefully at the end, we'll have enough cohesiveness, we'll be able to come to a decision. So explicitly
they're the question.
list those questions.
I think the list of issues of these process issues, we can shrink these down from the 5 days, 30 days, blah, blah, blah. We can shrink these down and add if there's other parts of other things that we need to consider, we can add
I
to
mean,
it.
you call them process issues,
process.
that confuses me.
Yeah, sorry about that. Yeah, sorry.
There's a list of questions that are relevant. What's the answer to each one?
I think that's right.
Just that you may find that you don't all agree on each question, but the point is, will you be able to agree at the end of the road on a final decision? You may win some, you may lose some in the individual questions, but you need to come to an agreement as to the final outcome. So.
Yeah.
May I ask a question,
Yeah,
Mr. Chair?
please.
Wrapping up soon, come back week and a half.
15th, yep.
I'm not pushing it, but I just want to give you all the opportunity.
I don't feel like personally I have issues with the way the code, the language of the code is laid out, legal issues. I think it's all taking the context of the information we have and trying to apply it, which I think is open session. Yeah. Okay, with that,
So as far as the list of questions, who comes up with the questions?
I
Should
have,
we all come up with our own list and we come together with it?
why don't we do our own list and you can send, if you'd like, you can send it to me and I will try and deduplicate. Or you can send it to Fred, we can send it to Fred, and then just come back. Okay, it's fine with me, yeah. Okay, yeah, so we're doing, lay out a list of questions and we have 3 points in time at which those would apply to. Yeah, more or less. Okay, given Given that we have about 15 minutes left, we'll just wrap up a little early. Outside, is there any other business any board members would like to bring up at this time? Anything else? Everyone good? Good. Okay, at this point in time, I'd entertain a motion to adjourn.
I'll make a motion to adjourn.
Second,
Second,
all in favor?
aye.
This meeting is adjourned. Thank you, everybody.
It's weird to talk about it. Can I just say that?
Weird to talk about.
It's weird to talk about it. We finally can. Okay.
It feels like there are so many things that are not well constrained. Go this way.
Yeah.